Subcommittee will come to order. Today, the subcommittee takes another step toward renewal of the Satellite Home Viewer Act, which enables satellite carriers to retransmit distant television signals under certain circumstances. Some provisions of the Communications and Copyright Acts expire at the end of this year, making reauthorization of this measure a must-pass undertaking. At the subcommittee's oversight hearing in February, I indicated that Congress should proceed with the reauthorization in the most straightforward manner possible, and I believe today, as I did then, that we should avoid in this measure collateral matters such as retransmission consent reform that are relevant to all multi-channel video providers, not just to satellite platforms. The discussion draft that we have under consideration today takes this straightforward approach. It renews for 5 years the provision allowing carriers to deliver a distant network station to homes under specified circumstances, which otherwise would expire at the end of this year. It reauthorizes the good faith negotiation requirements in the Communications Act that also otherwise would expire at the end of this year. It provides needed clarification regarding the provision by satellite carriers of significantly viewed signals by stating that a significantly viewed signal may only be provided in high definition format if the satellite carrier is passing through all of the high definition programming of the corresponding local station, also in high definition format. It directs the FCC to develop a predictive methodology for the reception of digital signals within 6 months in order to determine with accuracy which households are eligible to receive distant network signals. It makes technical changes to the law to reflect the fact that after last Friday, full power television stations are no longer broadcasting analog signals. In addition to these changes that are made by the discussion draft that is before us, there are additional matters that we could potentially address. One is developing appropriate incentives to encourage satellite carriers to provide local service in all 210 designated market areas nationwide. Today, DirecTV offers local service in about 150 markets, while Dish will soon offer local service in 182 markets. But that still leaves about 28 markets without any service at all. Most of the DMAs that lack local-to-local service today are in rural areas, and many of these markets do not have a full complement of network affiliates within the local market. In our parlance, they are referred to as short markets. While I understand that the numbers of subscribers in these unserved rural markets are small, their residents are highly vocal in expressing their views that they should have the same opportunities to receive local programming delivered by satellite as people who live in more densely populated regions. I'm hopeful that ongoing discussions among the stakeholders will lead to an arrangement through which all 210 markets will receive local satellite delivered service. Another matter for possible discussion is whether residents in short markets should be able to receive the programming of networks missing in their local market from an adjacent local market within the state of their residence. While satellite carriers can today import distant signals from any market, they're hindered in their desire to do so by the so-called grade B bleed problem that prevents them from offering distant signals to those households that can receive the signal of an out-of-market network affiliate over the air. That problem, as well as the larger short market concern, could potentially be successfully addressed by the subcommittee. Stakeholders are currently discussing the short market and local 210 matters, and it's my hope that these conversations will lead to an arrangement whereby we will be able to address both of these concerns when we conduct our subcommittee's markup. I want to welcome our witnesses this morning and thank them for sharing their views with us. I also want to say thank you to our Republican colleagues. primarily our ranking Republican member from Florida, Mr. Stearns, and his very fine staff for their excellent cooperation and collaboration as we have assembled the bipartisan discussion draft which is before the subcommittee this morning. And that said, I'm pleased to welcome Mr. Stearns for his opening statement.
Good morning, and thank you, Mr. Chairman, and thank you, frankly, for including us in a bipartisan fashion so that we could be instrumental and helpful in developing this draft bill. I would point out, in retrospect, the DTV transition went smoothly by most reports, and many of my colleagues have been concerned about it. I think this smooth transition will help everybody realize that there's probably few issues that we can talk about anymore about it because it's pretty much good news and we can move forward. Some consumers simply need to have their converter boxes rescanned for stations that have moved or might need a different antenna, and some stations may need to increase their broadcast power. But basically it appears that we could have saved some money, at least that's our position, but the good news is we can move forward. Turning to today's topic, I'm glad that we have a discussion draft of legislation to reauthorize the Satellite Television Act. The original satellite legislation in 1988 is credited with helping foster competitive video marketplace that we have today to the benefit of all of our consumers. Indeed, one of my district employees tells me how much he enjoys the satellite service, and my sense is this sentiment is equally shared by lots of consumers across this country, satellite subscribers. That is why we have to reauthorize this legislation each time it comes up for renewal. And that is why the discussion draft before us extends for another 5 years the authority of satellite operators to provide the signals of out-of-market station to subscribers who cannot receive their local stations over the air. In addition, my colleagues, the draft makes clerical and substantive changes to the statute to reflect the end of analog broadcasting. In particular, it directs the FCC to update for digital broadcasting both the predictive model and on-location testing rules for determining whether a subscriber is eligible for a distant signal. The draft also rectifies the FCC's poor implementation of the, quote, significantly viewed, end quote, provisions. These provisions added to the statute 5 years ago allow a satellite operator to provide subscribers in a local market with signals from a network affiliate in a nearby market if that nearby affiliate is watched over the air by a significant number of consumers in the local market. The statute prohibited a satellite operator, however, from carrying the significantly viewed affiliate in high-definition format if it didn't also carry the local affiliate of the same network in high-definition format. The FCC construed that provision to prohibit carriage of the significantly viewed affiliate in high definition at any moment of the day that the local station was not simply broadcasting in high definition. Because satellite operators find it difficult to match the transmission formats of the two stations moment by moment, they usually choose not to carry significantly viewed stations at all. So to address that, the draft makes clear that a satellite operator may carry the significantly viewed affiliate in high definition when the local affiliate is not broadcasting in high definition, so long as the satellite operator does carry the local affiliate in high definition when it is available, simply available in that format. An issue not addressed, but I'm sure will come up today, is what to do about consumers who cannot receive programming they truly consider local, either because they are missing local affiliates from one or more networks in their market, or because they have been assigned to a designated market area which is simply outside their state. My sense is there will be sympathy for such viewers. If we address this issue, however, we must do so in a way that clears existing regulatory obstacles rather than creates a whole new set of rules. As I've already mentioned, the video market is robustly competitive. In that environment, there should be less interference in the market, not more. Whatever we do, we should ensure that the satellite operators, the out-of-market station, and the owners of the content are allowed to freely negotiate. That is the best way to sure that consumers get as much desirable content as possible at simply the lowest rates. Anything else simply protects one company at the expense of another without really helping the consumers. And at bottom, this legislation is all about the consumers. So thank you, Mr. Chairman, for holding this hearing. Again, thank you for your allowing us to participate freely.
Thank you very much, Mr. Stearns. The gentleman from Massachusetts, Mr. Markey, former chairman of this subcommittee, is recognized for 2 minutes.
Thank you, Mr. Chairman, very much, and thank you for having this hearing. The Satellite Home Viewer Act is a law that this subcommittee revisits every 5 years to both reauthorize certain aspects of it and to review the applicability of particular provisions in light of changes in the marketplace. For example, it was 10 years ago that I was able to successfully offer the so-called local into local amendment that permitted satellite video providers to carry local broadcast stations in local markets, providing a major competitive boost to such satellite providers. 5 years ago, the subcommittee made other adjustments to the law, including adding provisions for the carriage of significantly viewed stations. The issues of short markets and significantly viewed signals must be dealt with in a serious fashion this year, and I look forward to working on them. Clearly, a major change that will need to be factored into this year's legislation is the conversion of the broadcast television industry to digital service. When I held the first congressional hearing on high-definition TV in this room in September of 1987, I never imagined that it would take 22 years to reach this moment. But it appears that the delay we enacted to move back the date from February resulted in over 3 million additional households that were able to receive greater education and awareness to occur, and for those 3 million homes to be properly prepared. The fielding of hundreds of thousands of consumer calls was facilitated by the ramp-up in the last few months of critical call center operations. This is a government program that worked. We made the transition. We have been able to move from analog to digital, compress the amount of spectrum that was needed, auction off the remaining spectrum for $20 billion, opening up a whole new area for entrepreneurial activity while giving a more flexible technology to consumers that in the years ahead will benefit them. So this has been a success, and it proves that the government, when it puts its mind to it, can work for the benefit of consumers. I thank you, Mr. Chairman, for conducting this hearing.
Thank you very much, Mr. Markey. The gentleman from Michigan, Mr. Upton, is recognized for 2 minutes.
Well, thank you, Mr. Chairman. I want to also commend you and Mr. Stearns and our staffs for working together. This has been a success, and it's critical that we send the proper message to consumers and subscribers and providers that we're going to act in a timely way that will not let this legislation expire. I look forward to working with you, as we've had a great relationship over the last number of years as we move this bill through the committee. This is one of the bills that our committee can take credit for in working in a bipartisan manner, and I'm glad that we continue that trend, and I yield back.
Thank you very much, Mr. Upton. The gentleman from California, Mr. McNerney, is recognized for 2 minutes.
Thank you, Mr. Chairman, for convening this hearing to discuss the legislation to reauthorize the Satellite Home Viewer Extension and Reauthorization Act. I would like also to thank the witnesses for coming here today to share their inputs on the legislation. A tremendous amount of behind-the-scenes work is required every day to ensure that Americans are able to turn on their television sets anytime to watch a program. The intricacies of how satellite providers and broadcasters interact are complex. Today's hearing should offer an opportunity to hear thoughtful evaluation of the proposed reforms. I'm excited to be a part of the debate, and I look forward to the hearing and the resulting legislation. Thank you, Mr. Chairman.
Thank you, Mr. McNerney. The gentleman from Illinois, Mr. Shimkus, is recognized for 2 minutes.
Thank you, Mr. Chairman. I, too, want to kind of highlight the successful transition on Friday. I've only received, I think, 4 phone calls in my congressional office on the DTV transition, and I have 5 DMAs that kind of cover my congressional district. A great success. Obviously, we've ushered the most significant revolution in television since the advent of color broadcasting. We cleared 24 megahertz of spectrum for public safety use, and that's what I've been focusing on for a long time. Provided first responders with $1 billion grant program for interoperability. Again, another thing that's been critical in this whole transition, 84 megahertz of spectrum nationwide for advanced wireless broadband services, and $20 billion in auction proceeds for the taxpayer. I also want to thank both government and industry for what they did in promoting this. The National Association of Broadcasters, the National Cable Telecommunications Association, the American Cable Association, Dish Network, and DirecTV, they're here today, along with the NTIA and the FCC, because we informed the public, and the public was able to respond as we hoped they would. It is important to note that if Shavira were not reauthorized, there would be more Americans affected by changes to their television broadcasts than during the DTV transition. That's the importance of this reauthorization. It is my hope that we'll have a frank and open discussion and not move hastily with this important legislation. I appreciate both Chairman Boucher and Ranking Member Stearns for calling this hearing. I look forward to hearing from the witnesses, and I yield back my time, Mr. Chairman.
Thank you, Mr. Shimkus. The gentleman from Nebraska, Mr. Terry, is recognized for 2 minutes.
I'd like to waive.
The gentleman will have 2 minutes of time added to his question period. The gentleman from Georgia, Mr. Deal, is recognized for 2 minutes.
Thank you, Mr. Chairman. I too appreciate holding the hearing. If it does make the news, it's unfortunate that some of my folks in North Georgia will have to learn about it by watching Tennessee television. I have a statement for the record that I will submit, and I yield back my time.
Thank you very much, Mr. Deal, and your statement, along with that of other members, will be included in the record. The gentleman from California, Mr. Radanovich, is recognized for 2 minutes.
Thank you, Mr. Chairman. I want to thank you and Mr. Stearns for holding this hearing to review the draft legislation reauthorizing the Satellite Television Act. And I appreciate both your leadership and your efforts to reauthorize this bill, continuing to provide satellite operators with the authority to provide the signals of out-of-market broadcast affiliates to subscribers who cannot receive their local affiliates over the air. My staff and I learned a few years ago, when many in my district lost their access to distant signals, we have a large population of constituents who are very vocal satellite subscribers, and while this problem has since been addressed, it illustrates the impact and importance of this legislation to many of my constituents. Although there are still a few issues that we need to work out, I look forward to working with the committee in a bipartisan manner towards a product that reflects the best interests of all television viewers, and I want to thank the witnesses for being here today, sharing your testimony, and Mr. Chairman, I yield back. Thank you.
Thank you very much, Mr. Radanovich. We're pleased now to turn to our panel of witnesses for this morning, and I want to thank each of them again for taking the time to join us here and share their very thoughtful views and comments with us on our discussion draft. Mr. Stanton Dodge is Executive Vice President and General Counsel and Secretary for Dish Network. Mr. Derek Chang is the Executive Vice President for Content Strategy and Development for DirecTV. Mr. Mike Monford is the Chief Executive Officer of NPS, one of the companies that is in the business of delivering distant network signals to households that are unserved according to the law's definitions. Mr. Preston Padden is Executive Vice President for Worldwide Government Relations for the Walt Disney Company. Mr. Paul Karpowitz is the President of Meredith Corporation. He testifies today on behalf of the National Association of Broadcasters. Without objection, each of your prepared written statements will be made a part of the record. We would welcome your oral summaries and ask that you keep those summaries to approximately 5 minutes. Mr. Dodge, we'll be pleased to begin with you. Mr. Dodge, if you could move that microphone very close to you and be sure that it's on. I think it may not be on. Actually, try pushing the button.
How's that?
That's much better.
Thank you.
In the technology subcommittee, I'm constantly amazed at the technical problems we have with microphones.
I am an attorney, not an engineer, so I apologize.
I think most of us probably fit that category.
Thank you for the opportunity to testify today regarding the renewal of the Satellite Home Viewer Act. The subcommittee's discussion draft provides a foundation to help shape how satellite TV providers will offer broadcast stations in the digital world, a world that began in earnest over the weekend with the digital transition. For that transition, the federal government, Congress, broadcasters, satellite TV providers, and other industry leaders came together in a coordinated fashion to further a key national objective. We hope that same spirit of cooperation can carry over to satellite TV's transition from analog to digital rules. The discussion draft includes a number of key provisions to help with that transition. However, standing alone, we believe it does not go far enough to provide consumers with the access to programming they desire. In each previous iteration of the Satellite Home Viewer Act, Congress has taken incremental and concrete steps to expand the ability of satellite TV providers to offer consumers the services they want while protecting the rights and interests of local broadcasters and content providers. At each juncture, satisfied consumers and enhanced video competition has been the result. Starting from the important building block that you've provided, we have the opportunity to again enhance competition and meet consumers' needs this year with additional reform in two key areas: designated market or DMA reform and serving all 210 markets. Mr. Chairman, members of Congress have noted that the need for DMA reform to ensure all customers have access to in-state broadcasters, yet in 43 states today that is not the case. A similar relief was provided for 4 markets in 2004, and importantly, consumers benefited, but I'm not aware of any evidence of harm to broadcasters in those markets. We believe at a minimum that a full national rollout of that program is now warranted, so that all consumers can gain access to key in-state news, information, and other programming. This would be a necessary and incremental step, but would not address our consumers' concerns fully. Broader DMA reform that provides consumers with the ability to receive the local stations of their choosing should remain our long-term objective, limited only by what technology allows. To date, broadcasters have failed to offer constructive DMA reform proposals and instead offer solutions that are consumer-unfriendly and technically not possible. It should be highlighted that satellite TV providers and broadcasters have not been able to resolve this consumer issue through private copyright arrangements in the decade since local-to-local service was introduced, underscoring the need today for affirmative action by Congress to achieve this result now. The second area of reform we can achieve this year is serving all 210 markets. Mr. Chairman, you and others on the subcommittee have expressed a desire for satellite-delivered local stations in all 210 DMAs. We believe that an incentive-based structure to achieve this result can be accomplished if satellite TV providers and broadcasters are willing to compromise and contribute to serving these economically challenging markets. We pledge our willingness to work with DirecTV and the broadcasters to find common ground and share your belief that this would be a pro-consumer result. We serve 178 local markets today by satellite, which is more than any other pay TV provider in the nation. We're proud of that investment and are equally excited to report that Dish Network will maintain its leadership position by launching 4 additional markets in the next month: Marquette, Michigan, Bend, Oregon, Alexandria, Louisiana, and Lima, Ohio. That brings the Dish Network total to 182 out of the 210 markets. The upcoming launch of these markets underscores our good faith commitment to continue to extend service to even more local communities, provided certain conditions exist. Critically, each of these 4 new markets has a local affiliate of each of the big 4 networks. The vast majority of the remaining 23 markets, however, do not, and we're unable to justify the substantial cost of investing in markets that do not provide the means to offer competitively viable service. That said, we're ready to provide service to the remaining markets, assuming the broadcasters are willing to partner with Dish Network and DirecTV to find a common-sense regulatory and financial framework for doing so, and that we have successful satellite launches to enable us to do that. As an industry, Dish Network and DirecTV have come together with a set of principles that should be included in any solution. First, all satellite providers should enter the digital world with the same set of rights, so consumers have true choice across all 210 markets. Regulatory disparities should not dictate consumer choices. For example, in any market missing 1 or more network affiliates, all satellite TV providers should have the ability to import a missing network affiliate to the entire market, regardless of whether there's bleed over from a nearby market. Second, the finite amount of satellite spectrum available for video programming should be addressed heads-on. As a national provider, Dish Network provides over 1,400 local broadcast stations today. If we move forward towards service in all 210 markets, realistic limits on the amount of local broadcast stations that can be shoehorned into our national satellite platform should be established. Similarly, broadcasters should be obligated to provide a minimum amount of local content to earn satellite carriage. Finally, making local stations available to all Americans for the first time on any platform is a noble but financially daunting undertaking. To achieve the same result for telephony, our nation has established a $7 billion a year universal service program, and there's an ongoing national dialogue on how to fund similar universal broadband coverage. Asking satellite carriers alone to expand to every market is a substantial burden, a burden that's not being asked of broadcasters, the cable industry, or telcos. There should be clear financial commitments from broadcasters to share in the burden of getting local TV service to remote areas for the benefit of our mutual viewers. In conclusion, increasing the number of communities served by satellite TV providers and the number of households able to receive in-state broadcasters are attainable and worthy public policy objectives for this year. The discussion draft provides a starting point to achieve these consumer goals, but does not go far enough. We stand willing to work with the subcommittee, broadcasters, DirecTV, and the content community to find the proper balance to accomplish both goals. Thank you again for inviting me to testify.
Is this all right?
That's pretty good.
I apologize. I'm neither an engineer nor an attorney, so I may be at a severe disadvantage here. Chairman Boucher, Ranking Member Stearns, and members of the subcommittee, thank you for inviting DirecTV to testify today regarding the reauthorization of the Satellite Home Viewer Act. We support the straightforward approach of the subcommittee's draft bill, which makes narrow but nonetheless important changes to the law for the delivery of broadcast stations in today's all-digital world. However, if the subcommittee chooses to broaden the draft bill to address other issues, we offer the following suggestions. These include modifying the DMA system, allowing distant network stations to be delivered in DMAs with missing affiliates, and further improving the significantly viewed rules. I would like to address each of these issues. First, I'd like to discuss improving choice in local service. Throughout the country, viewers in so-called orphan counties on the edges of DMAs cannot receive local broadcast service from within their own state. The 2004 reauthorization allowed consumers in a handful of these orphan counties to gain access to in-state local content. The results have been heralded by consumers and public officials. Even broadcasters who originally opposed these changes found their areas of service expanded and gained revenue from the additional copyright payments. These pilot projects provide Congress with a roadmap for applying this concept nationally. Representative Ross has drafted legislation that seeks to do just that. We urge its adoption. The approach is simple. It will allow consumers in these orphan counties the opportunity to watch their home state programming. Second, we would ensure that all consumers have access to network programming. Today, over 50 DMAs lack one or more local affiliates. Subscribers in such markets are ineligible for distant signals if they are predicted to receive even a faint signal from a neighboring out-of-market station. This is known as the Grade B bleed problem. It prevents subscribers in those markets from getting any network service via satellite. We see no reason why out-of-market stations should deny consumers access to network programming. There is a simple solution. Subscribers should be able to receive distant signals unless they receive a sufficiently strong signal from an in-market station. Third, I'd like to briefly address significantly viewed stations. We applaud your decision to remove the onerous equivalent bandwidth requirement. Yet satellite carriers face another obstacle in offering significantly viewed service, obtaining consent from broadcasters to offer stations outside their DMAs. Some broadcasters tell us that network affiliation agreements prohibit them from granting consent to satellite operators. Others have proven uninterested in granting consent outside their DMAs, even when they grant such consent to cable. We recommend that broadcasters be required to grant consent for significantly viewed carriage on equal terms and conditions to all distributors seeking such carriage. Alternatively, Congress could remove the retransmission consent requirement and instead compensate broadcasters under the distant signal regime. Last, Mr. Chairman, you and others have expressed an interest in satellite-delivered locals in all 210 DMAs. While DirecTV does not generally support a universal carriage mandate, we have worked constructively with Dish Network to develop a minimum set of requirements we believe are necessary for any such mandate to be imposed. By way of background, DirecTV has spent billions of dollars to provide local service to 95% of the country. In 10 short years, the satellite industry has reached 98% of the country with local service. Broadcast and cable, which have been in business since the 1920s and 1940s respectively, have still not reached those numbers. Cable still does not pass nearly 4 million households, a figure larger than homes in markets without satellite-delivered locals. Additionally, there are over 50 DMAs lacking one or more network affiliates, leaving almost 7 million households without a full complement of network programming. Universal carriage is a worthy public policy goal, but it requires an enormous capital investment that would be difficult, if not impossible, for us to recoup. And while the broadcasters would prefer that the entire burden be placed on satellite operators, this approach is neither economic nor fair to our subscribers, who ultimately bear the cost of such mandates. If Congress is to pursue a universal carriage mandate, it must do so in a way that shares the burden more equitably among all parties and accounts for other critical factors in the marketplace. We developed with Dish Network the following set of minimum criteria for your consideration: applying a 1/3 capacity cap similar to cables, limiting carriage rights to those stations with local content, requiring broadcasters to shoulder their fair share of the financial burden for expansion of their over-the-air footprint, prohibiting broadcasters from increasing the already substantial cost of such a mandate through retransmission consent fees, and as discussed above, addressing the missing affiliate problem and improving the significantly viewed rules. Mr. Chairman and members of the subcommittee, I thank you and your staff for all of your hard work. I'm happy to take your questions.
Thank you very much, Mr. Chang. Mr. Montford.
Chairman Boucher, Ranking Member Stearns, members of the subcommittee, I am Michael Mountford, CEO of National Programming Services, LLC, and we do business as allamericandirect.com. Mr. Chairman, before I get started, I just want to mention that I've been in this industry for 26 years, and no one has done more for satellite TV consumers, especially rural satellite TV consumers, than you, so thank you. I am pleased to have the opportunity to testify here today on behalf of not only my company, but also frustrated consumers everywhere. From my experience, consumers want their local stations first and foremost. However, thousands of people have come to our website to urge you, Congress, to allow them to purchase distant network signals without restrictions. They have several reasons. Maybe they have elderly parents who live in a different city. Maybe they have a child who goes to a school somewhere else in the country. Heck, you guys probably want to check in on your districts once in a while, don't you? These customers don't understand, these consumers don't understand why they can't purchase this product like they can purchase the New York Times or a Chicago radio station, for example. This country was built on the principle of the freedom of information. Consumers want that freedom, and they don't understand why Congress won't grant them those rights. I understand the concern about localism, and I would like to suggest a simple solution. Allow the consumers to purchase distant networks only after they purchase the local channel of the same network. This is allowed under the current legislation for significantly viewed stations from adjacent markets. Why not expand that? I urge Congress to take this bold step now and lift the restrictions on distant networks, because if you don't, more and more constituents are going to be frustrated by these rules, and they will be asking you, how could you have passed such a law? Hopefully you will agree with me that lifting the restrictions is the best solution. However, please let me comment on the draft legislation. It calls for a predictive model, which we agree is the best way to determine eligibility. The most important thing about a predictive model is viewability standard. The analog model right now calls for 90% viewability. That means 10% non-viewability. This would allow for 12 30-second interruptions during an hour program. And with digital, the interruptions are outages. They're gone. Clearly, that is unacceptable while viewing a digital signal. We urge Congress to require the FCC to adopt a minimum viewability standard of 99%. Better would be better. Even at that rate, it would allow for 12 3-second interruptions in an hour program. We urge the committee to ensure that no additional expense be required of the consumer to get their local networks. Congress did an excellent job with the digital conversion coupons. In the same spirit, we urge you to direct the FCC not to require additional equipment purchases by the consumer to get network programming. It just wouldn't be fair. The waiver system was put into the legislation because it is universally known a predictive model cannot be perfect, and it will not be perfect. The waiver system as it exists today is broken and needs to be changed. Your constituents are being denied service without the proper appeal envisioned by the legislation. 34% of all the stations we submit waivers to deny over 90% of those submittals. in essence, a third of the stations are denying all the waivers that come to them except for maybe a friend, a relative, or after a call from a congressional office. That is not the spirit of the law. That's not fair to your constituents. Fortunately, the digital conversion allows for a simpler, less expensive, more consumer-friendly waiver system that works in this way. A consumer who is denied by the predictive model can sign an affidavit under penalties of perjury and fines that they do not receive the signal. The provider can temporarily authorize that consumer and submit the consumer information to the broadcaster. The broadcaster can challenge by sending a clerical employee or a contractor to the home to view the signal for about 10 minutes. That's all it takes. With digital, the signal is either there or not there. It's not like analog where you see ghosting and artifacts. It's very simple. So in closing, I would urge you to listen to your constituents and lift the restrictions on distant network signals. Require the FCC to adopt a 99% or better viewability standard in the predictive model and fix the waiver system. Thank you very much.
Thank you, Mr. Montford. Mr. Patton.
Thank you, Mr. Chairman and Ranking Member Stearns. I want to begin by thanking this committee for creating a competitive marketplace for subscription television. It wasn't all that long ago that I was chatting with many of you about the problem that we only had one provider in the business, the local cable company, and when you think about what this committee has accomplished for the American people and for programmers like our company, it's really remarkable now the amount of competition that we have out there, and I think the committee ought to take great pride in that. I also want to emphasize we love our our satellite customers over here at Direct and Dish. Disney Channel and ESPN were two of the first channels that were willing to license their content to the satellite industry to help them get off the ground. They now carry many, many of our channels. They're excellent customers. We love them very much. We're appreciative to the committee for its straightforward discussion draft, and particularly appreciative that the committee avoided collateral issues such as completely trying to revamp the system of retransmission consent in the context of this legislation. I want to talk just a minute about the underlying compulsory copyright license. A compulsory license is just what it sounds like. It's a government act that takes private property, in this case our programming, from us and compels us to license it to certain customers designated by the government at a price set by the government. Now, I know that sounds like something that could only happen in Moscow or Tehran, but it actually did happen here in the United States. How did that happen? The answer is that back in 1976, the Congress found that it would be impractical and unduly burdensome to require every cable system to negotiate with every copyright owner whose work was retransmitted by a cable system. A reasonable position back in 1976. Then the satellite industry came along, and to be fair, Congress extended the same compulsory copyright license to the satellite industry. But when you extended it to satellite, you put a 6-year sunset on it, and you said this committee does not favor interference with workable marketplace relationships for the transfer of exhibition rights in programming. The committee expects that the marketplace and competition will eventually serve the needs of home satellite dish owners. Well, the good news is there now are workable marketplace mechanisms that can take the place of this government compulsory license. The industry created cable networks. This is after the compulsory license was first adopted. And there are now about 500 cable networks, none of which are eligible for the compulsory copyright license, which applies only to broadcasting. And yet, without the help of the government, the owners of these cable networks managed to get them in front of virtually every man, woman, and child in America. Just to give you one example, we have 2 networks at our company. One is called ABC, and the other is called ABC Family. They actually carry some of the same programs. ABC Family is not eligible for a compulsory copyright license, and yet we have signed agreements with these gentlemen at the end of the table to transmit that programming to the American people. we have a huge self-interest in wanting to get our programming, whether it's ABC or ABC Family, in front of every eyeball in America. And you can rely on that self-interest that we're going to get the product to everyone. The last time you extended the Satellite Home Viewer Act, you asked the Copyright Office to conduct a study of the underlying compulsory copyright license. They did that study, they released it last summer, and they concluded that the Congress should begin to phase out the compulsory copyright license and associated regulations. And we would urge that as this bill goes through the legislative process, all the relevant committees of jurisdiction, that we take a look at trying to get out of this business of government licensing where it's not necessary. In the meantime, we urge that you not expand the scope of the compulsory license, and in particular, don't adopt the proposal that has been discussed for adjacent markets. We are completely supportive of the idea of getting local in-state news and other local programming to consumers. It can be done today without a compulsory license. All it takes is an agreement between the station and either the cable operator or the satellite operator. There are many satellite or cable operators that today carry local news outside of the designated market area to other orphan counties, they're called, in the state. For example, our Philadelphia station news is carried down in Harrisburg. And recently, two of the leading Little Rock local news stations sent letters to DirecTV and Dish openly offering to sit down and work out arrangements to retransmit their local news in the Shreveport market. The problem with the adjacent market proposal is the proponents are talking about bringing the entire signal of the adjacent market station, not just the local programming. Our affiliation agreements with our affiliates give them exclusive rights to the network programming in their market. We have over 220 affiliates across the country. We only own 10 of those stations ourselves, and we're here today to stand shoulder to shoulder with our affiliates with the exclusive rights we have granted them and say to you, please do not abrogate our contracts. Please do not duplicate the programming of the local affiliate. It serves no public interest for consumers to be able to watch Desperate Housewives on 2 different channels at the same time. We're fully supportive of bringing in the local news and local programming. That can be done without expanding the compulsory license. Thank you very much.
Thank you, Mr. Padden. Mr. Karpowitz.
Chairman Boucher, Ranking Member Stearns, and members of the subcommittee, thank you very much for having me here today. My name is Paul Karpowitz, and I'm president of the Meredith Broadcasting Group, which operates 11 television stations in small, medium, and large markets throughout the United States. I testify today in my new role as chairman of the NAB Television Board. Local broadcasters appreciate the opportunity to talk with you about the issues of importance for local television service we provide to our communities. Chairman Boucher, I want to especially thank you and the committee staff for all of your work on the draft bill. Broadcasters support the discussion draft and look forward to continuing to work with you and other members of the committee as we move forward. As we discuss the draft legislation today, it's imperative that 2 principles remain paramount: localism and the respect for relationships that cover the distribution of programming and that have been found by the government to serve the public interest. Meredith Broadcasting, along with television stations across the country, works every day to embody the spirit of localism, which Congress has affirmed time and time again as a vital public policy goal. We don't charge our viewers to watch our programming. We rely on payments from advertisers to deliver a free service to your constituents. The draft we're discussing today is a positive step towards updating telecommunications law for the new era of digital broadcasting. Local broadcasters have stepped up and invested billions of dollars to complete the transition, and we're excited about the benefits that digital broadcasting will bring to your constituents. We're particularly appreciative that the draft continues to recognize the value of the current DMA structure. The DMA system, which is updated every year, enables broadcasters to serve every community with highly valuable local programming. Now, for example, our company owns and operates WHNS in Greenville, South Carolina. Now, 34% of the households in its DMA are located in North Carolina, and 4% are in Georgia. Now, WHNS provides locally attuned service to those North Carolina and Georgia communities every day, just as it does the South Carolina communities within its coverage area. Now, the nearest North Carolina television market to these North Carolina counties is Charlotte, which is 95 miles away, while Greenville is only 25 miles away. Now, these out-of-state communities all share with Greenville the same weather, topography, and have very close economic and cultural ties. WHNS serves these communities every day with news stories of specific relevance to the region, a service that cannot be matched by distant stations. Now, the satellite industry wants to change the law so that they can bring in duplicative network and national syndicated programming. Now, as a practical matter, let me explain what would happen if this were to occur. Our station in Greenville has exclusive rights from Fox and our syndicators to air popular programming, including American Idol, 24, and The Simpsons in its local market. Now, if a satellite or cable operator could import the signal of a Fox station from Charlotte, now including the exact same primetime programming into the Greenville market, it would significantly reduce our viewership and thus our advertising revenues. As a result, we would have fewer resources to serve the viewers, whether they're in South Carolina, North Carolina, or Georgia, with local programming, including news, weather, emergency information, and all the other local services our viewers have come to expect. In addition, a satellite or cable operator in a retransmission consent dispute could try to drop the viewer's local station in these North Carolina communities and instead carry a distant Fox affiliate, thereby depriving viewers of local information. It's important to recognize that cable and satellite carriers can already import news and information into distant in-state counties today without changing the law. Finally, we appreciate the efforts of Congressman Stupak to make sure that no community is denied access to local programming by their satellite carriers, and we hope to work with the committee to address this problem. As you consider reauthorization of Shavira, I urge you to preserve our ability to serve every local community. We are very appreciative of the important steps reflected in this draft bill and believe the subcommittee is headed in the right direction. I thank you for your efforts so far and look forward to answering any questions.
Thank you very much, Mr. Karpowitz, and thanks to all of the witnesses for their testimony here this morning. I'm going to ask unanimous consent that a variety of letters we have received addressing issues concerning the reauthorization of the Satellite Home Viewer Act be made a part of the record. These have been shared with Mr. Stearns and his staff. Without objection, they will be included. Mr. Chang, let me begin my questions with you. You have noted in your testimony that in order for service to be provided in the markets that do not have local interlocal service today, those approximately 30 markets across the country, that the carrier would have to find a means of getting the broadcast station signal to its uplink facility. And the uplink facility for some of these very rural markets could be hundreds, if not more than 1,000 miles away, I would assume. On the other hand, the law as of several years ago required that for every market in which local interlocal service is provided, that the satellite carrier have a local receive facility within that market in order to receive the signal from the local broadcasters. Why would it not be sufficient to simply take the backhaul, to take that local broadcast signal from the unserved market to a nearby market, perhaps an adjacent market, where a local receive facility by the satellite carrier would be located? Why would that not be sufficient?
As I said earlier, I'm not an engineer, so I don't know the details, but my understanding is the cost to build out the facilities within each of the markets that we're not serving, in addition to the transmission costs.
Well, I'll grant you there are costs associated with it, but the cost of getting it to something as close as an adjacent market where a receive facility is already in place would be substantially less than the cost of having to take that signal hundreds, if not more than 1,000 miles to one of the satellite carriers' uplink facilities. So let's assume, for the sake of the question, that getting it to a receive facility would be satisfactory. Mr. Dodge, would you confirm that it is? Is that a means of getting it to your uplink facility?
I'd say that that's a constructive suggestion towards reducing the cost, but you still have to pay for the fiber from, if you will, the adjacent receive facility back to our uplink facility. So our position...
Back to your uplink facility?
Sorry, back to our uplink facility.
Well, doesn't that already exist? Because the purpose of that local receive facility is for you to receive the signal in that market of the local broadcaster and then take that over your already in place infrastructure back to your uplink.
Correct, and we use we backhaul via satellite or via fiber, and the question would be, you would need additional fiber or spectrum or satellite capacity to uplink it, to bring it back to the uplink facility. So
you're saying that the existing infrastructure by which you are taking the signals of the broadcaster in that adjacent market back to your uplink would not be sufficient in and of themselves to enable you to carry the signals from broadcasters in the unserved market next door?
I believe so.
Okay. Let's check this. Let me ask both of you if you would go back and examine this and maybe talk to some of the engineers. Sure. We occasionally do accept testimony from engineers here. It's not always lawyers. And give us an answer as to whether or not, A, we are right in saying that providing that signal to the receive facility nearby is a possible means of lowering that backhaul cost. And if it is, would the infrastructures that typically are already in place to take the signal from that receive facility back to your uplink be satisfactory for this purpose? Let me, on the same issue, slightly different aspect of it, ask Mr. Karpowitz and Mr. Patton a question. I have heard it estimated that the cost of backhaul for all 210 unserved markets, the new capacity of, by whatever means would have to be added, would be about $30 million collectively. And the broadcasters have a tremendous interest in getting all 210 markets served. It's their signal that would then be disseminated to a broader group of viewers in a way the viewers would like to have that signal. And among the suggestions made by DirecTV and Dish in their offering to you in terms of how they would be willing to serve these 210 markets was a suggestion that on some terms broadcasters be willing to help share in that cost, given the benefits that inure to you if those markets are served. So Mr. Karpowitz and Mr. Patton, your company owns some television stations. What's your answer to that? Is there a possibility that you would be willing to help them in some measure share in that cost?
I think what we have heard are a lot of different numbers relative to what that cost might be. And at the NAB, we have established a subcommittee that consists of technical people, real engineers, and members of our board that are from small markets that would have a very real stake in this, in this type of decision. So we would stand very ready to work with the committee and work with the satellite operators to continue discussions about exactly how that would work, whether it be fiber, additional satellite, whatever. But I think there's still not enough information relative to what the real costs might be for us to make a determination as to what our level of participation might be.
The broadcast industry has had this proposal from the two satellite carriers now for more than a week, and I know you have a committee that's looking at it. Do you have a time frame within which you intend to have a response?
We actually have had one committee meeting already, and it would be my hope that we could get back to you very shortly. I don't have the specific days in my mind yet, but it would be our intent to get back with you very quickly.
Okay. I'm going to pursue one other question, and the chair will be lenient with other members in taking time to ask their questions. These are important matters. The current law contains a curious legal consequence that with the digital television transition and the termination of analog television broadcasts by the full power television stations, virtually every viewer in America today is classified as being in a white area and therefore being eligible to receive distant network signals. Now, of course, that was never the intent of the law, and the old law, the current law, says that the standard for eligibility is determined over whether or not the viewer can receive, by means of an outdoor antenna, an analog signal of grade B intensity. And of course, then when the analog signals were turned off, nobody was getting analog signals, and so no one could get analog signals of grade B intensity. Therefore, under current law, you've got this curious consequence that technically everyone is eligible to get a distant network signal. Realizing that problem last year, I asked the satellite carriers to refrain from offering distant network signals until we had an opportunity in this reauthorization to address that problem and correct it. And commendably, all of the carriers responded favorably and sent letters indicating their restraint. And so far, no one has taken advantage of this existing loophole in the law. But I just want to ask Mr. Dodge, Mr. Chang, Mr. Munford for your statement of continued adherence to that pledge not to utilize that loophole in the law. There was some discussion last week about whether that might change. And given that little bit of confusion, I thought it appropriate to get on the record a statement from all three of you that you would not seek to utilize that loophole while we're in the process of changing the law to say that it's digital signals that are in question here, not analog signals. Mr. Munford, can we get that pledge from you?
We currently are using the existing analog model because the digital model which we've ordered is not ready yet. So as soon as that becomes available, we'll be using that. In the interim, we are telling customers who get rejected by the analog model that we'll rerun them once we get a digital model, and we'll continue to use that digital model. And we will be testing those consumers. As I said in my testimony, there's an easy way to test consumers. So we will be testing consumers who get rejected under the digital model. And depending upon those tests, we'll go forward.
Okay. I take it that means yes, you're going to continue to restrain and not utilize.
That means yes, unless we're disenfranchising a bunch of consumers, and then we may come talk to you.
Well, Mr. Munford, we're rewriting the law in such a way just as to contain a clarification of this issue and use the word digital instead of analog. And I would assume until that happens, you would continue to abide by the terms of the letter that you sent last year and not seek to utilize that loophole in order to serve those customers. Is that correct?
We'll never seek to use that loophole.
Thank you, Mr. Munford. Mr. Chang, I'd like to hear from you.
I'd just like to say
as briefly as possible.
we
This
were
could
not-
be just one word, a yes would do, but
yes,
if you want to
we will-
elaborate,
we will-
that's fine.
Yes, we will.
Thank you. Mr. Dodge, I know you're not delivering distant network signals, but if something happens that should enable you under some circumstances to do that, would you agree to this pledge?
We would.
Thank you, Mr. Dodge. That was a good answer. That was right to the point. Thank you. My time has expired. The gentleman from Florida is recognized for 5 minutes.
Thank you, Mr. Chairman. And I think we on this committee should feel blessed because you serve on judiciary, and I know judiciary's had a hearing. They'll have a referral on this. I don't think the Senate's had a hearing yet. But when they go into the right to carry signal and the copyright protection, you'll be right there protecting us, and perhaps the nuance of this bill will be protected. But my feeling is just overall that the bill has to move forward, and I'm not sure many of us on this side or either side want to hold this bill up to solve this problem, which seems a little bit complicated. Just as a observation, Mr. Patton mentioned how cable is solving the problem, so I would ask Mr. Mountford, the solution in which cable is doing this problem, is that something that could be as a paradigm or something that we could work off in this bill?
Not sure if I understand the question.
The missing affiliates problem that Mr. Patton mentioned. So basically he's saying that the local broadcasters had been solved through the cable, and he described how they did it. I don't know, did you remember what he said?
I think you're referring to my reference to the fact that some cable operators are carrying local news and other local programming from an adjacent market station today.
Yeah.
And there's no reason that we're aware of why a satellite distributor couldn't make the same
So
arrangements.
that's my question, and I'll let each, Mr. Dodge, Mr. Chang, yes.
That would be something we would have to look into. It's something that I haven't even considered or we haven't even thought about yet, but it sounds interesting.
Okay, Mr. Chang?
Is that, can you hear me okay?
Yeah, sure.
From DirecTV's perspective, we do blackouts, as Mr. Patton suggested, but they're difficult to implement. We do them on an irregular basis, mostly for sports product, which is kind of mandated by various sports leagues and teams and such. And to be quite honest with you, it is a very difficult process to implement from an operational perspective for us. We do it because we are forced to. Our customers do not like it. To do what Mr. Patton has suggested would in essence be the reverse of that, which is really literally to black out probably 90% of a channel from an adjacent market to just then show the local news that they are allowed to pass through to the adjacent market. And I think to do that, across the country itself would be difficult. It would compound incredibly our operational issues. I think also from a customer perspective, to sit there and have to see a black screen for kind of 90% of the time in order to see local news doesn't make a lot of sense. It's not a customer-friendly proposition.
Answering this question. Mr. Dodge?
And I guess I would just reiterate what Mr. Chang said. I mean, we really look at it as a threefold issue, which is at the top of the list. We agree with you, Ranking Member Stearns, that this is all about the consumers. And quite frankly, to reiterate what Mr. Chang said, they don't want their screen black 90% of the day, let alone paying for that privilege. And additionally, while the screen is black, they'll miss important emergency weather alerts because they won't see the crawls that would be coming through on the programming from that broadcaster. Additionally, there are substantial technical differences between satellite and cable, where they have people generally in all their local areas that can monitor the signals 24/7. We have a single staff who is, as I said earlier, is monitoring about 1,400 different channels, so it's just basically impossible for us to monitor and black out programming at all. And finally, from a legal perspective, we're not quite sure that the broadcasters have all the necessary rights to do what they're saying. So, for example, do they have the rights to the copyrights to send through the national programming clips that they include in their broadcasts and advertising? And similarly, while the cable folks are able to splice in alternate programming, we don't have a similar provision in our statutory license that would allow us to do it. So we couldn't do it even if it was technically feasible.
So you're saying right now it's not technically feasible in your mind?
It's not.
And that's what you're saying, Mr. Chang? That it's not technically feasible to do this? I forget the idea that you're blacking out. I mean, that could be worked through, but you're saying it's not even technically feasible.
I don't know if strictly it's technically infeasible. It would be very difficult to implement.
Okay.
I know that.
Mr. Patton?
Yeah, I think Mr. Dodge said he wasn't sure it was lawful under his statutory license, but what we're talking about is simply an arm's length marketplace negotiated license where the local station says, as the two Little Rock stations have said in their letters that are in the record to both DirecTV and to Dish, we, the local station, would like to license you in a normal contractual license arrangement, our local news to carry to these in-state viewers. And I believe that all of the satellite operators are required to dedicate a certain percentage of their channels for public service programming. And maybe one thing you might think about is, rather than worry about a blackout, simply license the local news and carry it on one of those public service channels that you're obligated to transmit anyway. I think it would be a tremendous service to your customers and might help attract customers.
Anyone else on this question? Do you have anything?
I guess my only thought would be the beauty of our 6 o'clock news and our 11 o'clock news, it runs at 6 o'clock every night and 11 o'clock every night.
Right.
So compared to trying to schedule around a blackout of a sports event, which is a live, fluid event that there's no time frame, our 6 o'clock news runs 30 minutes every night. And I would think that with server technology available as it is today, that it would not be that difficult to set up a system like that.
Okay, I just...
Well, I'm sorry, all the networks, I'm told, and certainly our network have given their affiliates the necessary clearance for the national news that is included in these local newscasts, so there is no legal impediment in that regard.
Just going to ask one more question, Mr. Chairman. The bill as such is we're trying to get the FCC to update the predictive model and the on-location test for digital broadcasting. Mr. Chang, what would be your advice to the FCC And then I'll ask Mr. McPadden. What would be your advice to the FCC?
I think we said we are willing to adhere to the FCC's digital predictive model.
So the predictive model that they have now, you could adhere to?
We would adhere to, yes.
Okay. Yes?
Well, yeah, again, I am not an expert relative to what that would entail, but my sense would be that we continue to look at it, but I don't think we have any major objections.
Yeah. Thank you, Mr. Chairman.
Thank you very much, Mr. Stearns. The gentlelady from California, Ms. Eshoo, is recognized for 5 minutes.
Good morning, Mr. Chairman, and thank you for holding this hearing. To all of the witnesses, thank you for being here and providing your testimony. I have two questions. The first of Mr. Dodge. As a longtime supporter of public television, I'm concerned with the disparate treatment that DISH is affording our nation's local public television stations. As you probably know, I've reintroduced in this Congress the Satellite Consumers Access to Public Television Digital Programming Act to address DISH's refusal to negotiate meaningfully on the carriage of local multicast public broadcast programming. It's been brought to my attention that DISH is carrying the HD signal of the big four stations in 85 markets, and yet to date you haven't carried the HD signal of public television stations anywhere except in Alaska and Hawaii, where you're legally obligated to do so. In my district, for example, DISH is carrying the big four networks and KRON in HD, but not in my local public television station, KQED. It seems to me that DISH is engaging in a pattern of discriminatory behavior against public television stations. Stations which are funded, get some funding from Congress annually because of the quality of their non-commercial educational programming that they deliver to the American public. I think that this behavior is reminiscent of past discriminatory actions, including the practice of placing public television stations and Spanish language stations on a second satellite receiver. So my question to you is, why is DISH almost alone in refusing to negotiate a carriage agreement with public TV that provides for non-discriminatory carriage in HD and at least some multicasting? I think if there's a market failure here, that Congress should address it, and I will continue to pursue that. Now, what's really deeply disturbing to me is that it's been reported that DISH has targeted the Hispanic caucus members and telling them that if my bill were to pass, DISH would be forced to stop carrying Spanish language channels. You know, and I know, and many of us know, that this is really completely false. My bill does not prevent satellite carriers from carrying any program. It merely mandates the carriage of all digital PBS programming. And I know what, I've heard the argument before that you don't have enough room, enough space, and that you would have to drop some. And I would suggest that you drop some of your pay-per-view channels that carry soft porn. I'd take PBS any day over soft porn. So would you address yourself to the question as to why you refuse to negotiate a carriage agreement with public TV that provides for non-discriminatory carriage in HD?
I'd be happy to.
I don't know about happy, but you can explain it, yeah.
Well, with all
I really can't, I mean, I ask this every time we have a hearing on this subject matter. And others have negotiated an agreement, you haven't. What's the sticking point here?
Well, I guess first and foremost, I believe we have for years engaged in good faith negotiations with the public broadcasters, and during that process, the FCC actually had a proceeding to determine how best to implement HD must carry. The public broadcasters fully participated in that hearing.
What was the most recent discussion you've had with the FCC?
On that issue,
I mean, with public broadcasting people. What's the most recent meeting you've had with them?
I do not know the answer to that question.
Well, you can get that back to us.
I definitely can.
I really think that that there shouldn't have to be legislation for you to get to do this. And it seems to me that you have stayed in a place where I don't really think distinguishes you, and you should look for ways to distinguish yourself. I mean, you do other things that are good, but this is, you're cheating, I think, or holding back on the consumer, because PBS is important in the life of the American people. And I think what they do is has already been set down and is a gold standard. And this business of not having room and can't, you've got these pay-per-view things, you can make some room there. So I'd like you to get that information back to me. To Mr. Karpowitz, I know that Mr. Ross, who's a member of this subcommittee, is raising a very important interstate issue. I think I have an important intrastate issue. I have constituents in the southern portion of my congressional district that would prefer to view the local news of San Francisco or San Jose, but they're in the Monterey-Salinas DMA. Now, I mean, there's a lot to be said, obviously, about localism, and it's best served when the consumer has the choice to receive the broadcast signals of the community that they identify with. I don't know if you can appreciate the geography of the district, but the identification is in the very southern part and not with San Francisco that might as well be 500 miles away. That's not what they identify with. And I know that these issues are politically sensitive, but for many consumers in my district, these distinctions defy logic. How do you think localism and consumer choice are balanced correctly in the new digital age?
I think
to me that we've got some kind of blurred old lines dictating this.
I don't know if the lines are old to the extent that the DMA lines are changed every year, are very up to variability, and every year they
How about old looking?
But to answer your question relative to your constituents in Salinas, Monterey, if in fact the cable systems down there wanted to make a deal with the broadcast stations in San Francisco to get those newscasts, that can happen today. There is no reason to change the law. Where the broadcasters have said we have a problem with what Congressman Ross was proposing was the ability for the viewers in Salinas, Monterey to get two Wheels of Fortune, to get two Desperate Housewives. We don't think that's necessary. But if in fact there's interest in the community to get local news out of San Francisco, that can happen now without any change in the law.
All right. Well, we may follow up with you on that, but I appreciate your answer. And Mr. Dodge, I'd like you to get back to us. And I wish that we didn't have to use the hammer of legislation to get these negotiations done and done well and out of the way. I would really urge you. I mean, you said that you've negotiated in good faith. I don't know when that was. I don't know if it was 5 years ago, 2 years ago. So I'm asking the date, but I would use this hearing to once again urge you to come to the table and really take care of this. For you to be leaving out public broadcasting and carrying some of this other stuff, it just doesn't square off with consumers. So thank you. Thank you, Mr.
Thank you, Ms.
Chairman.
Eshoo.
If I could address one of the points you brought up.
Very, very briefly, Mr. Dodge.
Thank you. First, we are working with Congresswoman DeGette's office further to the last hearing to actually set up another round of discussions with PBS.
I'm sorry, I didn't hear you.
So we are working with Congresswoman DeGette's office to set up another round of discussions with the folks from PBS, as we said we would at the last hearing.
Well, I'd like to be included in those, if I might. I think that I can bring something to that. You may not think so, but I think I can.
I have no reason to believe you wouldn't.
Okay,
thanks.
you.
Thanks very much, Ms. Eshoo, Mr.
Chairman?
Dodge. Well, Mr. Munford, we're going to move on to the next member now who's going to be asking questions. The gentleman from Georgia, Mr. Deal, is recognized for 5 minutes.
Thank you, Mr. Chairman. I have this mental picture that we're all standing on the loading dock of a train station. Some of us are holding the hands of some people that we call orphans. Some of them are wiping their eyes and they're sniffling. And people are sitting in those rail cars that are saying, come on over, we'd like to adopt you. And we're being told as we hold their hands saying, well, Congress has said you don't belong to them. We've let you be adopted by somebody else. And the only answer I've heard today is to say to those orphans, well, we'll let you go to their house and you can watch the local news, but as soon as the news goes off, we're going to turn that television off and you got to come home because you belong to us. Congress has let us adopt you. And by the way, you got to pay us because we have adopted you. Now, that just doesn't make a whole lot of sense to me. And the question, I guess, that comes up is, why is that fair? And if we're not going to deal with it today, what other piece of legislation and what time frame is going to be appropriate to deal with that issue? And I'll just let y'all talk.
Well, I would say it is fair, and there's more than that. There's a precedent for it. As Mr. Chang and I both said in our testimony, this issue was recognized in 2004 and was fixed for 4 communities to great success for the consumers, and as far as I can tell, to no harm to the broadcasters. And the reason I say that is because if there was some harm, I think we'd be hearing about it for the last 4 years. And I haven't heard a peep. So I think it is unfair.
I would reiterate what Mr. Dodge just said. I think that we feel there is a solution, and it's been proposed, and we're willing to support it. I think that what's difficult for us is what these folks have suggested in terms of and what you reiterated, which is having it only being able to watch the news and then getting sent home, and that's difficult for us to implement.
I agree, and it's not only just the orphan next door, it's the orphan anywhere else in the country. My wife has a sister who lives in a different city, and her sister calls her up when she's watching a different program and sees a commercial that she wants my wife to see. That wouldn't happen if we were only showing the news. And it doesn't happen, obviously, but there's one other quick point I'd like to make about the predictive model. This sheet tells, you all got in my written testimony, it shows the mathematical formula on a predictive model and how much outage is predicted. And I also have a disc for you, a DVD, that shows you a 30-second outage, a 7.5-second outage, and other outages, which we can supply to you now or later. Thank you.
Mr. Deal, the rationale that has been articulated to us for Mr. Ross's adjacent market proposal is to get in-state news and other in-state local programming to viewers. And we're just here to explain that that can happen today. It does happen today. As I said in my testimony, we own a TV station in Philadelphia. There are cable operators in Harrisburg who believe their customers have an interest in seeing our Philadelphia newscast, and they provide it to their customers today. And we got the 2 leading local news stations in Little Rock to send letters to Dish and to Direct saying, we're ready to sit down with you and make arrangements for you to carry our Little Rock news into these Arkansas counties in the Shreveport market. To date, I don't believe the local stations have even gotten a response from Dish or Direct.
Is your answer that they have to turn it off after the news goes off and go home?
No, my answer is that in our free market society, it is wrong for the Congress to abrogate free market, negotiated, exclusive licenses just so people can watch Desperate Housewives on 2 channels at the same time. That's wrong,
I
sir.
understand your concern for your affiliates, but I don't understand why you would take your programming and put it on abc.com and totally bypass your affiliates if that's your concern.
Well, actually, we don't totally bypass our affiliates. We have included our affiliates in that operation. We use a geolocation service. There are 4 commercial positions in each program on abc.com, and the local affiliate gets to sell the ad in one of the 4, very similar to the shared advertising arrangement we have on our network. We're also concerned about local advertisers who the local station says, would you like your ad to run in Desperate Housewives? Well, yes, I would. And I'm going to pay you a lot of money to run in Desperate Housewives, but if you bring in a second Desperate Housewives at the same time, some portion of the audience that local advertiser expected to reach is not going to see his ad because they're watching the out-of-market signal. We are completely sympathetic.
Even if
on
that
in-state news.
advertiser has to try to attract that audience from across state lines, which doesn't make a whole lot of sense to me, quite frankly. Yes, sir.
I guess I would say that given the example that I gave in my testimony about our station in Greenville, we would be challenged to continue to produce 6 hours of live local news every day if, in fact, our advertisers were being whittled away by other signals coming into our market. I mean, if Mr. Mountford's sister-in-law was watching a commercial coming in from Indianapolis versus the commercial that I ran in Greenville, that's a viewer that I've lost.
Well, you say you got 4% in North Georgia, and I used to be in that 4% area and had to buy television in Greenville to reach 4% of your market. Got a lot of votes in South Carolina by running political ads in Greenville, but they realistically could not vote for me. Those 4% in that Northeast Georgia area that are having to be tied into your Greenville station, I think in many instances would much prefer to be tied in to the state of Georgia where they live. And I do not see why we allow these artificial negotiated arrangements to interfere with that, and or why there can't be some realistic accommodation to it other than going dark or going blank or having to duplicate.
Thank you very much.
Who in the world would like to have two versions of Desperate Housewives is beyond me.
Yeah. Thank you very much, Mr. Deal. The gentleman from North Carolina, Mr. Butterfield, is recognized for 5 minutes.
Thank you very much, Mr. Chairman, for convening this hearing today, and I particularly want to thank the 5 witnesses who have come forward. I'm sorry I missed your testimonies. I have a written copy of your testimony in my binder, and when I get a chance, I will try to scan most of those. Mr. Chairman, as you well know, I am relatively new to this committee, and so this subject matter is new. And so I'm trying as best I can to learn it and get up to speed on it. When I first got appointed to this committee, the broadcasters in my state came to my office and very painfully and carefully worked with me in trying to understand Shavira. And I'm still struggling to get the detail. And so this hearing today is certainly very helpful. I'm going to ask unanimous consent, Mr. Chairman, that my opening statement that I was not able to give be included in the record. I had 2 questions that I brought to the committee, and Mr. Chairman, you asked one of those 2 questions, and so I only have one that I would like to very briefly ask, if I can find it. Well, it has escaped me. Here it is. It deals with the terrestrial loophole, and I want to address this again to Mr. Chang and to Mr. Dodge. The terrestrial loophole permits vertically integrated cable operators to deny programming to certain multi-channel video programming distributors when such programming is not transmitted by way of satellite. What can you tell me about the terrestrial loophole and any harm to customers who might not be able to get this programming?
I think I'd let Mr. Chang take that first as the programming expert.
Yes. We do believe we're at a disadvantage to the cable operators on account of the terrestrial loophole. In the areas that this exists, particularly in the Philadelphia market, we do see penetration rates in terms of our subscriber take-up that are lower than in other areas. And we think it's due to the lack of local sports programming. I think that's simply put, we're at a disadvantage because we don't have that programming to share with our customers.
Do you concur with that, Mr. Dodge?
I do, and I would just add, I don't see why the method of distribution is relevant to whether or not we have access to the programming.
All right. Thank you. I yield back, Mr. Chairman.
Thank you very much, Mr. Butterfield. The gentleman from Illinois, Mr. Shimkus, is recognized for 5 minutes.
Thank you, Mr. Chairman. My first question being Mr. Karpowitz. I know there's been talk on the regional aspects and crossing state lines. In my opening statement, I mentioned that I had 5 DMAs that cover my congressional district. So depending upon the intensity of the campaign, you make choices and you eventually buy. You guys like it, we have to buy all, even though the broadcast sector of who we're going to hit could be very, very limited. If the Ross bill, how would the Ross bill affect smaller broadcasters? If in my 5 DMAs, if they all had to compete with St. Louis, how would they affect, the other 4? Or really, the other 4 probably would be competing with maybe Indianapolis and maybe Memphis. And so you would have a sector there that would be challenged. What's your response to how they affect the smaller broadcasters?
Effectively, what would happen in those smaller DMAs with a St. Louis or an Indianapolis station coming in over the top, not only with local news, but with additional NBC programming or CBS programming or Fox programming and additional syndicated product, I think it would put a tremendous challenge on those broadcasters in the smaller DMAs to have the same resources available to them to continue to provide the services that they provide today, because their audience would be splintered, quite frankly, so that instead of having all of the audience for 60 minutes, you may have, audience coming in from KMOV in St. Louis would be coming in over the top. That's the risk that we run, that these small broadcasters, and this is a very difficult time for small broadcasters. I have a station in Flint, Michigan that is going through an incredibly difficult time right now. And to put this burden on those broadcasters whereby they would have additional signals coming in over the top, I think it would really hinder their ability to serve their local communities.
So, it's not just the news aspect. I mean, I think that's where a lot of members come. It would be, if it's broadcasting in, but there's the basic programming would, in essence, compete with the local broadcasters' paired programming.
I think we have tried to be, we are sensitive to the fact that, these out-of-state stations are, I guess, in-state stations, out-of-DMA stations that may want to come in, and the constituents in those areas, those counties, may want to see their news from the capital, for example. We understand that, but we think that if that is limited to local news, that should be adequate to serve their needs. But we don't see any need for any duplicative programming to come in over the top of those smaller broadcasters.
What about the issue of emergency service broadcasting for the elements that may be occurring?
Well, as I indicated in my testimony, in most cases, as we've looked at these, in most cases, the severe weather would be closer to their DMA base. So in the case of Greenville that I had given in my testimony, if Greenville's only 25 miles away, they are certainly going to be responding to severe weather that's happening up in North Carolina more quickly than Charlotte would be, which is 95 miles away. And beyond that, I think every broadcaster understands that it's their responsibility to make sure that they cover everyone in their DMA with emergency services, weather updates, and so forth. So whether it's at the far northern end of your DMA or the far southern end, it's our responsibility to cover that.
Yeah, I will tell you, in just about a month ago, maybe 5 weeks ago, we had what was called an inland hurricane in southern Illinois, which in essence wouldn't have been covered by St. Louis, just on the periphery. It would be covered by Carbondale, would have been covered by Marion, would have been covered by maybe Paducah, maybe Cape Girardeau, but it was a major event that the public really had to be concerned about. Mr. Padden, if you could wave the magic wand and eliminate all statutory and FCC video regulations so that Disney could negotiate directly with any entity that wants to distribute Disney programming to anyone who wants to watch it, would you?
Absolutely. We negotiate with every program distributor today for all of our networks and programs except ABC, because ABC is covered by the compulsory license. If the compulsory license and the related regulations went away, we would be working 24 hours a day to see that ABC was in front of every set of eyeballs in America, because that's how we make our money. And the more rules the government layers on top of this compulsory license, the more mixed up the market gets.
Do you think that approach would lower costs?
Yes.
Thank you, Mr. Chairman. I yield back.
Thank you very much, Mr. Shimkus. The gentlelady from the Virgin Islands, Ms. Christensen, is recognized for 5 minutes.
Thank you. I'm similarly situated to my colleague here from North Carolina, being new and new to some of the issues. So some of my questions may be very basic, but One question to Mr. Padden. On the issue of securing so-called orphan counties with in-state local programming, you testified that the satellite carriers can today cut deals with local stations to retransmit those signals. Do your affiliation agreements prevent your affiliates from granting retransmission consent to send the signal outside of that station's DMA?
There is nothing in our affiliation agreement that prevents our local affiliate from making an arrangement for their local news and other local programming to be distributed by anyone they want.
On the issue of the DMAs, from listening to Mr. Karpowitz and looking at your testimony, you think that it's fine the way it is, we don't need to change it, because that has come up in several hearings. And I'd like to just know what all of the panelists feel, if we can work within the DMAs as they exist today, or do we need to change them?
I believe we can.
Because it would seem to me that, I mean, I come from a small community, so I can't even use mine, but if, say, the southern part of North Carolina was in with South Carolina, and might be much more similar to the northern part of North Carolina, so the DMA should work. Does everybody agree, or do we need to change how the DMAs are configured?
The DMA is determined by the Nielsen Rating Company, and it's a measure of to which city is most of the viewing from this county directed. So it's a living definition that changes every year based on to which television market the people in that county are directing most of their viewing. So by definition, it reflects consumer preferences.
And we can address all of the emergency, the situation that Mrs. Shimkus talked about is kind of scary if they can't get the information because they're based out of St. Louis.
Right. I think as a practical matter, what we have found is that the information coming from the DMA that those so-called orphan counties are in is certainly more relevant and closer to those counties than the information that would be coming from a distant DMA.
Congresswoman Christensen, thanks for the question. If the DMA system works and people do want their local station, however, how do you respond? How do I respond? And I have to respond to this about 5 times a day now, to a consumer who says, how come I can't get your channel from San Francisco or from New York? And my only response is because that's the law. People know that channel's up there and that it's on their Dish Network system and they want to receive it. Why can't they?
Mr. Chang?
From DirecTV, we believe that the current DMA system, it's not perfect. It's also probably not wildly broken. I think we highlighted earlier in my earlier testimony some of the simple fixes we would probably make to the extent that this became part of a broader discussion, including dealing with the orphan counties, the significantly viewed issue, the grade B bleed, and all that sort of stuff.
And I guess not surprisingly, we do favor DMA reform, because I guess in the broadest sense, we think as technology evolves and in the current market in which we live, where content's available free on the internet, consumers should be able to decide what's local for them. And for every case where there might be an example where you're in an out-of-state DMA and that's actually closer to your home, there's probably a case where it's not true. For example, in Wyoming, there are many people in the Denver DMA where Denver is actually about 300 miles from their house. And similarly, although there's a parade of horribles that gets rolled out every time the concept is floated, we do have examples today of the 4 markets where this is approved in 2004. And if you look at Vermont, I don't think you hear the Albany broadcasters or the Boston broadcasters complaining that the folks in southern Vermont have access to Burlington signals.
Okay. The committee staff had mentioned in the briefing that satellite carriers, and I guess I would direct this at Mr. Chang and Mr. Dodge, had problems with the interpretation of Section 340 of equivalent bandwidth being too restrictive and therefore limiting the practical utility of it for satellite carriers. Could you explain what concerns you might have with that? Or are there no concerns with the interpretation of equivalent bandwidth as being too restrictive.
I think as it, in the prior bill, and I believe it's being, or in the current draft, it's been changed to language that we think is fine in terms of the equivalent bandwidth.
We agree.
Thank you. Thank you, Mr. Chairman.
Thank you very much, Ms. Christensen. The gentleman from Oregon, Mr. Walden, is recognized for 5 minutes.
Thank you very much, Mr. Chairman. I appreciate the panel and the testimony today. And I want to thank Dish Network. Mr. Dodge, thank you for, I guess, your opening statement announcing you are going to be in the Bend market, local into local, by July 9th. We appreciate that in the Bend market. I was down at another hearings going on in the O&I committee, so I wasn't here for the openings. And I'm a big fan of local into local, and I would certainly encourage you to continue on down the rankings until all communities that have television have that ability, and the viewers have that ability to see their local stations on their satellite system. I want to talk a little bit about this notion of the evils of blacking out the rest of the duplicative programming and the effect that has on viewers. I have before me a channel changing device. And it seems to me that during the course of any day, people pick and choose programs on different channels, whether it's over-the-air broadcast or cable or satellite. And it seems to me that if I want to watch a out-of-market local program, I have the ability to push this button. I won't, because God only knows what I'll do to this monitor. But I'll never get it back. But I'd have that ability, wouldn't I? I mean, this happens on your systems, right? People change channels.
You certainly would.
They do that with pay-per-view, right? The pay program ends, they're done. It goes blue screen to the next pay program until they buy, right? Or some...
That's true for pay-per-view. I mean, I think the general concept is, as you're scrolling through, people don't want to see a black screen 90% of the day.
But they might see a blue screen with a pay-per-view sales pitch, right? So, I mean, you do that.
Well, but, you know, quite frankly, if you're watching the news and you don't want to change the channel, you want to just roll into the next program.
Can you get that mic a little closer, too, speaking of interruption?
If you're watching the news and it's rolling into your next favorite program, you know, why should you have to change the channel when if you otherwise just...
Well, yeah, but I think viewer habits are such. People do watch the local news, and I know this will be sacrilege to those in the networks, but they may choose a different network newscast than the one that... I mean, they change, right? They make those choices. So it seems to me that you have a legal way to do non-duplicative programming the customer wants to see by, it can be offered to cable and satellite customers without a change in the law, correct? If you negotiate it for their local content?
We're actually not... I'm not certain of that. Mr. Padden said that ABC has granted the right to all of its affiliates to broadcast its...
Well, you'd have to negotiate it. It's their local programming. But you'd have, under the current law, you're allowed to do that.
Well, included in their local programming are advertisements for which they may not own the copyright and therefore have the rights to allow us to broadcast it outside of their DMA.
Correct.
International content as well, although Mr. Padden says...
Right, but they'd have to work, that'd be their responsibility
to
make sure they're offering you something they're legally allowed to offer, right?
It would, correct.
And that doesn't require a change in the law.
If they have those rights, it would not.
Right. That's all I'm talking. I'm not talking about selling you the Brooklyn Bridge. You know, if they have the rights to sell it, they should be able to sell it. Mr. Padden, isn't that correct?
That's absolutely correct, and it's being done today by cable operators.
Mr.
In addition to ABC, we also know for a fact that CBS and NBC have agreed that any content that of theirs that would end up in our local newscast, we would have the right to move that forward to a provider.
And I certainly, with a district of 70,000 square miles with all kinds of media markets around it, am not unsympathetic to my constituents, certainly, who would like to see Oregon news. If you're out on the Idaho border and 360 or 400 miles from Portland, I still have people out there who say, I'd like to see the Oregon news, but what I'm hearing in this hearing is there's a way to do that within the law to get that product. Because they don't say, I want to see, pick your show. They're really talking about how they get that local news, and that seems to me could be done now. And I know that you raised a technical issue of how you would go in and out of that local programming that would come up to your satellite systems? Now, I confess I spent almost 22 years in the radio business, and actually have been on the cool end of a soldering iron a number of times, wiring in those satellite receiver systems to pick up different programming. And they're pretty sophisticated, yet simple if I was able to make it work, systems of switching. And couldn't the local stations, as you do your uplink, simply have a coded digital switching, Mr. Karpowitz? Isn't that the way it works?
Yes, you would build in a tone,
yeah.
and the tone would trigger a switch at their head end, which would then trigger the program.
I mean, this happens all the time. So I think that's important for the committee to know. It's not, this is sort of normal backroom stuff that the engineers do all the time. And I guess my final question would be to Mr. Mountford, because you said how many interruptions should we allow per hour in terms of this digital programming, I think you meant. Don't you face that problem with satellite distribution, especially during the sort of sun cycles in the spring and the fall? Don't you have interruptions as well, and storms?
Absolutely.
And I'm not picking on satellite, but
No.
you get your share of digital interruptions. So does cable, and so does broadcast now.
There's rain fade, and there is sun interruptions. But in the predictive model, what you're saying to a rural consumer is that if you're saying it's 90% viewability, you're saying that 10% of the time we're going to allow your signal to be totally unviewable. Now, mathematically, that would work out to, as I said before, 12 30-second interruptions, which is totally unacceptable, or even 6 one-minute interruptions in an hour program. I truly believe that the FCC has to tighten that standard because it is digital, because an analog interruption
Is
wasn't
much
as bad.
different, much different. I agree. Mr. Padden, Mr. Karpowitz, do you have any?
We favor the Congress adopting the noise-limited signal intensity standard in Section 72.622E1 of the FCC's rules.
And you were just reading that again this morning, I bet, that whole rule.
It's fascinating. Yeah. You know, I would, if I could make one point, I've just met Mr. Mountford. He's a wonderful man, a great advocate. He's in the business of selling ABC to people. Now, how does that happen? We have no contract with him. We spend billions of dollars a year creating this programming. He's selling it to people by satellite. He neither owns the network nor a satellite system. This is entirely a creation of the Congress, and it helped get the satellite industry launched, but the existence of 500 other networks that we managed to get out to satellite customers without government intervention strongly suggests, as the Copyright Office found, that we ought to be looking at how to phase out of what we've got here, because I just think the existence of someone who's selling something that's not theirs through transmission facilities that are not theirs suggests that there's something wrong here.
We pay for that programming. It's called the copyright fee, and so we do pay for it. We also pay for all of our transmission facilities, our backhauls, through a lease agreement. Thank you.
My point only is you're paying a price set by the government rather than through a negotiation with the people whose programming you're distributing.
And the government has chosen to set that price as a fair price.
Thank you very much. Thank you, Mr. Walden and gentlemen. The gentleman from New York, Mr. Weiner, is recognized for 5 minutes.
Do you guys want us to leave while you keep doing this? Mr. Chang, does DirecTV produce content in the classic sense? Does it produce programming?
We do produce a limited amount of programming.
I mean, I don't mean like what's on TV at 8 o'clock, 9 o'clock, and 10 o'clock, but that's not your primary model here, is it?
No, our primary model is the distribution of programming and content.
I just think it's worth us taking a step back here as a group and recognizing that consumers do have a near-term interest of wanting to choose from moment to moment what's on their screen. But there's also a higher imperative that Congress has always endeavored to protect, to make sure that content in the general sense was incentivized by the marketplace, and that we figure out how we get people a rich amount of content distributed in a way that they want to get it. Now that latter part, how they want to get it, is changing every single day. But one of the things that we try to do, and I think that Mr. Boucher's draft does, is it protects the idea that, yes, you naturally want to be able to go out and distribute Mr. Padden's content any which way you want, but we need to figure out a way to incentivize Mr. Padden's company to produce it. And that's ultimately in the long-term interest of our constituents as well. If you're not going to have Desperate Housewives getting produced at all if we don't have a model that allows Disney or ABC to produce the content, negotiate for how it's distributed in the marketplace. So I think we have to be careful not to say, yeah, why shouldn't someone be able to get 5 or 6 or 8 Desperate Housewives? Because that's a model that would guarantee them in a very short time of being able to get none. That's also our, now I don't know in Mr. Deal's metaphor, which I frankly lost track of, I don't know who was holding the hand and whose hand was being held, or who was on the train, or who was driving the train, or what the next stop was. But I do know that if we look at what the interests are of consumers, we can't only look at the near-term decision that they may want to make to see content. We also have to figure out a model that works, that incentivizes creation. Now, sometimes the industry is going to have to work that out, and they did it woefully badly in the music business. But sometimes government's going to have to help by saying that we're going to be much tougher on making sure people can't pirate information. So we strike that balance here, and I think that Mr. Boucher's bill does that fairly well. If these seem to be kind of shotgun relationships between your companies, it's because we are trying to find the way to ensure that we incentivize content being produced. It's not in Mr. Chang's job description to be all that concerned about it. You're trying to figure out a way to get consumers as much choice as you can, zipping it all over the place. And I can tell you, as someone who represents New York City, I probably would benefit. When Mr. Shimkus says probably the opposite for me, I probably could run statewide just advertising in New York on New York City, because the guys in Albany wouldn't have a chance competing against the resources of a New York market. So I just think we have to remind ourselves that the interest of the consumer is not a near-term thing. It's also a larger framework that we have, going back to the Cable Act in the 80s, we've tried to balance and structure. Maybe we don't get it exactly right. Mr. Chang, do you want to respond to that?
Sure. I don't disagree with you. I think that it is in the interest of the consumers long-term to deliver as much content as possible that they would want to see. I think that where you talk about incentives for the content producers to make sure that they can invest in their content, similarly, I think we need to talk about the not having disincentives for folks like us on the distribution side who provide a very valuable service to customers, not to invest or having to invest in unnecessary technologies or capital investments, such as potentially duplicating signals and thereby wasting valuable bandwidth in terms of having to black out, for instance, programming that's not the local news. When in fact we think the impact of what we're talking about here is limited in nature, and I think in the limited areas where it's been done in the past, we don't believe that there has been a significant impact. So I don't think there's a huge disincentive from a content producer standpoint. And for folks like Disney, who also own multiple other content sources, I think it's up to them to decide how they want to divvy up their own internal resources and whether they put it on ABC.
Well, but it's also under their control to decide when they're making contractual arrangements of how and when their product is going to be distributed in local markets, to not have the specter of you guys hanging over and says, well, we'll just drop in someone else here. I mean, I think that's the problem. The problem is they have a right to some control over their content, and I think you agree with that. And you say that, well, in some selected cases, they should lose that control, and I think that's where you and I part company. I mean, I think that if we both agree, Mr. Padden says that his solution, and Ms. Carpenter's their solution for getting local content, they say, oh, it's a relatively small thing. You say your solution is a relatively small thing. The problem is your relatively small thing would have a rather dramatic structural problem in those communities that you're seeking to serve, meaning essentially Mr. Padden would lose the right to make exclusive arrangements, essentially.
Right, but I would ask the question, I mean, what percentage of the population are you talking about, and how would that really impact the
I just come back to,
programming costs?
if you want to abrogate our contracts for the purpose of the customer being able to watch the same show on 2 channels, I just don't see the public benefit.
No, we're trying to respond to Congressman Ross and his desire to have his constituents, as well as several of the other congressmen, have their constituents be able to watch relevant programming and try to do it in a fashion that is not a huge burden to any one of us from an economic standpoint.
Well, can I interrupt this conversation and ask this question, Ms. Chang? Do you agree that you shouldn't be in a position to offer Desperate Housewives on 2 different stations in the same market?
What I would agree with is that we are trying to deliver relevant programming to customers.
Understood. But would you take a stab at my question? Do you agree that you shouldn't have it in your rights to distribute 2 Desperate Housewives, not the housewives, but the show, 2 Desperate Housewives
That I would agree with.
to the same customers?
Listen, I think that when you take into account the law and the various contracts, it is what it is in terms of what we're allowed to do. All we're asking for is to try to be responsive to various members and their requests that their customers can see, their constituents can see relevant programs.
Well, I've already gone well over my time, and I thank you, Mr. Boucher. But I think that if we can reach one conclusion, that the answer is no, they shouldn't be able to, because that severely undermines Mr. Patton's ability to negotiate a contract and therefore, by extension, to produce the content, then I think we're at a foundation where Mr. Boucher starts us, which is, let's try to solve the other problem. And I think you'll find broad agreement here, and I think we want to solve Mr. Ross's problems, but I don't think that what your solution is a real structural undermining, at least in those communities, a structural undermining of the thing that makes Desperate Housewives available once, let alone twice. But I thank you, Mr. Chairman.
Thank you very much, Mr. Weiner. The gentleman from Arizona, Mr. Shadegg, is recognized for 5 minutes.
Thank you, Mr. Chairman. As I sit here and listen to this debate and review the issue, I've got to tell you that it drives into my mind the issue of our inability to discern reasonable requests from unreasonable requests. Mr. Chang, you just struggled mightily to try to answer Mr. Weiner's question about whether or not people should be able to see Desperate Housewives 2 times. I guess you'd have the same problem with people demanding to see it 20 times on the same TV station in one town. And the problem with that is that Mr. Patton's constituents, the people he represents, have to have the capital to make attractive programming. And if you are allowed to sell that programming in one particular area 2 times, 5 times, 8 times, each time it gets sold or made available in the same area, and you say they're demanding this, I don't particularly see that demand. I'm not sure I know why anybody watches Desperate Housewives, but I don't know why you have to be able to watch it twice at once. And I guess it seems to me that with regard to local news or with regard to sports, I can understand some issue. But how do you deal with the fact that Mr. Patton has, right now, a certain level of exclusivity that lets him market that product in a way that creates enough economic value that he can produce something that's worth watching? And how is Mr. Ross's problem not solved by what's currently available? Yes.
Again, I don't know specifically how many people we're talking about and what sort of overlap we're talking about whereby people would get duplicative programming such as Desperate Housewives and what that would do to his advertising.
Let me just stop you right there. If we don't know how big a problem is this, why are we struggling here in this hearing so mightily to overcome it?
Well, we don't think it's a large problem. I don't know the specific number, I guess, is a better characterization. And I guess the question that I would have back is to these folks is, if we end up having to duplicate signals and thereby investing a lot more in terms of our satellite infrastructure, our maintenance infrastructure, is that our burden to bear alone to solve this problem, or are they going to pay for that?
Well, why don't you ask the customers to pay for it? If the customers really want that local paying, why don't you make that pay-per-view? Mr. Patton, let me ask you, have I accurately expressed your concern with regard to
having the same show made available multiple times in one market or otherwise destroying the economic value of what you produce? Yes, you've captured it precisely. And let me give Derek an example. Under Mr. Ross's proposal, the satellite operators would be able to bring the Richmond stations to every household in Northern Virginia in the Washington, D.C. television market. They represent about a third of the market. You'd be duplicating the exclusive network programming in a third of the market. It would have a devastating impact on the Washington station. On the other hand, if what we're trying to do is get Richmond news to folks in Northern Virginia, there is absolutely no bar under current law for you to negotiate a deal with the Richmond station to carry their news to your Northern Virginia customers, and we would encourage you to do that.
Mr. Mounford, you said that the only thing that stops this from happening right now is the law. I guess I would say to you that's right. It's the law of property rights. Mr. Padden has a property right to the program he produces. If you diminish that property right, you can destroy the value of the program he produces and we'll have nothing worth watching. It seems to me nobody's looking here at the choices people make. If somebody chooses to live in some backwater town in Idaho or Montana or Wyoming, and they say, but I want to be able to watch the Miami local news station in Miami because my sister lives in Miami and I want to look at the news she's watching, maybe you should make that available to her for a price and let her pay in Wyoming to watch the news programming in Miami, Florida. But I don't see how you should do it in a way that costs Mr. Padden his business.
That's exactly what we want to do, offer it to the person in Wyoming at a price.
So she can buy the second right to watch Desperate Housewives.
Well, it wouldn't be Desperate
You'll
Housewives.
compensate Mr. Padden for the diminution in the value of Desperate Housewives in that marketplace.
We would pay what, either a negotiated agreement or a set copyright fee to the providers. That's what we do today for people in Wyoming, for example. And a lot of the rural customers, it wouldn't be a duplicated program because they don't get it. They don't get their station. That's why I'm advocating the 99% viewability standard, because at 90% it's going to say you get your station, but 10% of the time it's not there. But Congress says you get it, so that's the law. That's not right.
I think he's now saying, Mr. Padden, that he's willing to pay you, but I don't see that in the legislation before us.
No, if the government wasn't involved, we would have every economic incentive to meet with and license our content to anybody that can get us additional eyeballs, because that's in our self-interest.
That's the property right you're selling. Thank you.
Well, Mr. Shadegg, thank you very much. All of the members present have been recognized for questions. We want to thank our witnesses very much for your testimony here today. This subject is always interesting. Every 5 years we address it again, and it seems to get even more interesting over time. So thanks to all of you for excellent testimony today, and with that, this hearing is adjourned.